If I may seek your Lordship's indulgence in mentioning one
May,
distinct
may,
item.
may I please, Your Lordship? My Lord,
Wait,
my Lord,
someone is speaking before you. Yes.
Yes, my Lord, it is IA Criminal number 42 of 2024. It's with regard to suspension of sentence, and it has not been listed for over a month, and there are some new developments. So if your Lordship permits, it may be taken up as the last item for today, after the list.
You can list it in the next DB.
Next DB also, my Lord.
Oh.
Because the new development is that the address of the informant, who is the respondent number 2, she was earlier staying at BSUP, Loipu. However, as she has been found to sell liquor and heroin, the UDNPA department evicted her from the said BSUP, and notice upon the said respondent becomes impossible. We have tried our best to locate her address, but till date.
So in the next DB,
Sure.
simply because we can't really do anything
Yes.
much today. Yes.
Obliged, my Lord.
Yes.
may I please, Lordship? My Lord, item number 10 and 11, hearing matter today, my Lord.
Yes.
Well, I want to argue physically, my Lord. So may I pray this matter may come on 11th of December, my Lord.
On the brief made by Mr. Sanjay Kumar Medi, learned appellant for the state, for the learned counsel for the appellant, lists this matter on 11th.
11th December. 11th December.
It's a Wednesday? Okay, 11, 12, so and so. Okay, 2024. Yes.
Highly object.
For motion, item number 1.
None appeared for the petitioner on call.
Last time also.
It is seen that the petitioner was also absent when the matter was called out in the last court date dated 06/11/2024. In view of the above, we find it fit to dismiss the instant writ petition on default on the absence of the learned counsel for the petitioner. Yes.
Admission, item number 2.
Yes. The respondents, I think you were to file an affidavit giving us a detailed information as to what is going on the road that needs to be repaired. Aizol Tenzol Lunglei Road.
Yes, exactly, Lordship.
Yes.
Actually, in fact, this order was asked on 23rd October already. Since then, no reply has come out till date.
So the last order was along with the photographs, details along with the photographs as to what type of works have been brought within the said road.
My lord, I was contacted by the concerned officer, and I was requested to pray for at least 2 weeks' time to file the affidavit, because they're going to have a meeting in this regard.
Okay. It appears that additional money was sanctioned by the
Yes.
state government, 3.6 crores. Is it
Yes,
for the
my lord.
repair of
Yes,
the
Lordship.
said
Yeah,
stretch of
3.6
road?
crore.
I
Yes.
have intimated the order, my lord. It's duly received, and accordingly, meeting is called for.
Okay. In the meantime, the counsel for the petitioner, you also see what's going on.
Yeah, definitely, Lordship, I'll do that.
Let us find out, because this stretch of road is very important. Lunglei being the
Yes.
second district in the state
I
of.
don't, may kindly be listed next week?
No,
because
they
the
have prayed
order
for-
since-
Listen, they have prayed for 2 weeks' time, okay, to do their homework as to what is required to be done by them in terms of this court's order dated 30/10/2024. So if we give them too short a time, they will not have the time to take the required photographs. Okay.
At least they might
Ground
make
inspection is
attempt.
required. Yes, ground inspection is required. Okay,
At least
find out.
for showing photographs also, they might make repair also.
See, and before the photographs are taken, maybe they'll be given time to do some quick work in that stretch so that better photographs come out, isn't it? Yes. Heard Mr. J.C. Lenun Asanga, learned counsel for the learned counsel for the petitioner who appeared through VC along with Ms. Mary L. Kiante, learned government advocate for the respondents. The learned government advocate has prayed for 2 weeks' time to take steps in compliance with this court's order dated 30/10/2024, wherein the state government were required to file an affidavit bringing on record as to what steps are being taken pursuant to the approval granted amounting to rupees
3.6.
3.6 crores for the purpose of restoration of the road between Aizol, Thengzol, Lunglei Road, within brackets 100.00-143.00 kilometers, km. Okay. Besides, the affidavit is, no, in the said affidavit, the photographs as to what type of works have been done is also to be brought on record. Accordingly, as prayed for,
Lordship, may I please seek one?
After
Actually, in the last quarter, you were given liberty to file additional affidavit.
Meanwhile, the learned counsel for the petitioner may file an additional affidavit if so required with regards to the progress of the repair within the stretch, mentioned stretch of road.
Much obliged, Your Lordship.
Item 3.
Lordship, this is a writ appeal challenging the pre-judgment and order passed by Honorable Justice Michael Zothan Kuma in writ petition number 41 of 2023. And the pre-judgment and order was passed on 24/5/2024. And Your Lordship, the main ground is that the appellant was an official in Mizoram Rural Bank serving for more than 30 years. And due to the misconduct, allegedly misconduct, that is disbursement of loan accounts, I was charged with disciplinary proceedings. And I was alleged to have committed misconduct in sanctioning 6 number of loan accounts. And for that reason, Your Lordship, I was removed from the service. And the removal, in fact, was challenged before this Honorable Court. However, the judge, the Honorable Justice Michael Zothan Kuma, in passing the judgment and order on 24/5/2024, Your Lordship, dismissed the petition, Your Lordship. And the judgment and order, in fact, was, Your Lordship, it is Roman number 1, Your Lordship. Roman number 1.
Yes, so what are your grounds for in challenging the said judgment and order? Because it appears to be a very well-reasoned judgment.
Lordship. The thing is
So
that, Your
what's
Lordship,
wrong with this judgment?
Yes. in this judgment, Your Lordship, particularly, may I kindly take you at page number Roman 4 of the judgment, Your Lordship.
Yes,
There is para number 9. May I kindly take you at here, my Lordship? Para number 9. As can be seen from the memo of charge sheet issued to the petitioner has been charged with disbursement of loans to business units which were not in existence. Besides giving loans by violating bank's instruction without scrutiny, verification of units, security documents, etc. Your Lordship, the reason why I'm just mentioning is that, as we have seen in this para number 9, as per the judgment herein, I was alleged to have been disbursed the loan of business units which were not available, and no proper verification was conducted as per the judgment herein, Your Lordship.
yes.
But during the hearing, as well as during at the petition also, it was clearly mentioned that proper verification was conducted, and the assigned persons, the expert persons, already visited the units and proper verification was there. And Lordship, for that particular purpose, Your Lordship, may I kindly take you at my clarification, which is enclosed in this particular appeal. That is, Your Lordship, may I kindly take at page number 46 of the petition. Page number 46 of the petition. Your Lordship, this page number 46 onwards is a lengthy one. I'm not reading it whole. But the thing is that, Your Lordship, the imputation number 1 is written here in para number 15.1. That is, as per the charge sheet, the imputation is given, and, Your Lordship, during the disbarmental proceeding, a written statement was submitted. That is also reflected here in this very page number 46. And as per the written statement, the allegation was properly clarified. And thereafter, Your Lordship, the findings, page number 47, shows findings of the inquiry. The finding of the inquiry is that violation of law and manual 2020 is proof in respect of disbursement. In respect of disbursement, Your Lordship. And like that, Your Lordship, it is categorically explained in my written statement during the parliamentary proceedings, and even during the petition, even during the petition proceedings also, Your Lordship, everything was properly clarified. And the main reason of the challenge is that, Your Lordship, as per the findings of the inquiry officer as well as the disciplinary authority, I was allegedly found to commit misconduct in respect of disbursement of loan, disbursement of 6 number of loan accounts. But, Your Lordship, the removal order, in fact, was passed against me, which is gross, Your Lordship. Actually, it's not proportional to the alleged misconduct. For that reason, Your Lordship, I have come to this honorable court challenging on the ground that the punishment, in fact, was not proportional to the allegation, Your Lordship. So, I pray this honorable court to kindly admit this appeal and list for hearing, Your Lordship.
Yes, okay. Anything the respondent?
No, my lord, may kindly be admitted for hearing, my
Okay,
lord.
since it's not objected, we'll
Unless-
admit, because, see, whether there are grounds or not, in the impugned judgment, which you have mentioned, the learned single judge had observed, okay, that the courts are not to interfere into the merits
My
of the
lord,
case as
exactly.
such. It is the disciplinary authority who has the full power to look into these matters. So it is not to look into the merits. That was the observation. But you're saying that now that the merits need to be re-examined because there's some gross
Lordship.
miscarriage of justice, according to him. Okay, so we'll look into the matter. We'll admit the
Lordship.
you heard Mr. T. Nunciama, learned counsel for the appellant. Also heard Mr. C. Chana, learned counsel for
Standing
the
counsel also.
standing counsel for the respondents. Having heard the submissions made by the learned counsels, we find it fit to admit the appeal. Accordingly, appeal is admitted. List for hearing in due course.
Much obliged, Your Lordship.
Item 4.
May it please your lordships. Yes. My lords, this is a matter of condonation of delay for 2,345 days. Yes. However, I would like to bring your lordship's attention to the order dated 5/9/2024.
Yes.
Yes, wherein I had submitted that several respondents have died and passed the
So yes,
superintendent.
so an amended cost title.
Yes.
So
How-
have you done that?
I have done that. However, my lord, this has caused some complications in the application as well as the main petition, my lord, the appeal memorandum, because I have mentioned certain respondents as per the respondents number. So this has before it was 35 respondents. However, it has now come to 23 respondents. This has caused a dilemma on my side. So if I may be allowed to revert back to the original cause title.
But if they have, here you had mentioned that they have quit or
Yes.
died,
Yes.
then they can no longer be the party, isn't it? So you'll have to, or if not, you simply withdraw the instant, this thing, then you can make the necessary corrections on the body of your writ petition, is it? Yes, isn't it? And then file afresh.
In the last court.
Because here you've mentioned that some of them had
Yes.
died, some of them are no longer interested because they have left on superannuation. Now reverting back, it'll be, you're going back to your word, you can
Yes.
do that.
However, my lord, in the last court date, I was advised that if these persons were not impleaded, if these persons were not included in the respondents, it would also affect their pension benefits as well. So I am in a state of dilemma. So
But will that be appropriate? Because unless you mention or quit the job or died, isn't it? And that person can no longer be made of this thing. You withdraw, file afresh.
my lord.
Okay, so that those people who are no longer living today, maybe their representatives, someone will be there to represent something, yeah, substitution or something. Because here you have clearly mentioned
Yes,
the
my lord.
reason, and then again saying that let them remain as it is. You find out what's to be done. Then you can file afresh
My
anytime.
lord.
Isn't it? Because here in the DB, which is consisting of a CJ and
Yes, my lord.
others, I
Understand.
think not be appropriate, isn't it? Yes. Hurt Miss Valentina, so and so, learned counsel for the applicant / appellant, who has prayed that she may be allowed to withdraw the instant IA along with the writ appeal with a permission to file afresh if so advised. In view of the above, as prayed for, the instant IA along with the writ appeal is allowed to be withdrawn with a permission to file afresh if so advised.
Much obliged.
For hearing, item number 12.
May it please your lordship. My lord, the present writ appeal was filed by the writ petitioners in WPC number 131 of 2021, being aggrieved against the impugned judgment order dated 17/3/2023. My lord,
The
there-
judgment is against, the appeal is against the judgment passed by,
Justice Nelson.
Justice Nelson Silo.
Oh, then
The main grounds taken in this appeal is that they have oversighted the amendment portion in the relevant rules. And we are challenging the illegal absorption of the private respondent number 6, my lord. The state respondents had absorbed, provincialized one higher secondary school.
so is the private respondent duly represented today?
Deemed served, notice deemed served, but not contest. He chosen to not to contest in the appeal. There was delay. IA was already disposed of. In that also he did not
Okay,
contest.
let's see, because
You'll
if
also
it's
make
going
kindly
to
see-
affect the rights
Yes, my
of
lord.
the private
Order
respondent.
dated 7th of February,
Yes, let's see.
7-2.
Appeal is admitted, isn't it? At the time of admission hearing,
7/2/2024, my lord. Notice deemed served upon the
yes,
respondent number 6.
notice is deemed served, but, and we had gone ahead finding that Dusty, it was served through Dusty. And then many dates were fixed. So what do we do? Do we go ahead with the hearing? When
My lord,
private respondent is up?
my lord,
Yes.
this matter at this stage needs not require lengthy hearing, my lord. There's some, the state respondents have also now been convinced with the situation that they have oversighted the relevant amendment rules. Coming to the point, my lord,
Okay, yes, okay. You're speaking for the state respondents.
no, my lord.
Then,
Coming to the point, my lord,
huh.
earlier there was no specific provincialization rules for higher secondary school. So in that point of time, they have adopted the provincialization rules of middle school and high school under the state government, which was enacted in 1994. And by adopting the rules of 1994, which is in respect of specifically for middle school and high school, the state respondents had adopted that rules by applying to the for a provincialization of Zakuma Higher Secondary School, which is at Kolosip district. And in terms of the rules of 1994, my lord, the relevant rules, Rule 6 proviso, it provided provision for absorption of the existing principle. But thereafter, there was amendment in 2002. And in terms of the amended rules, my lord, the existing headmaster principal has to be observed as teacher, lecturer. That is the main ground, my lord.
Okay, yes, so let's,
And recently, my lord, the state respondents have also now come up with one particular rules before I address to the writ appeal, my lord. These rules is specifically made for higher secondary school, notified on 22nd September 2023. And if I may take a lordship to Rule 3. And before that, my lord, I'll read the introduction part of the notification, first page. In exercise of the powers conferred by proviso to Article 309 of the Constitution, and in supersession of the middle school and high school provincialization rules 1994, notified on
this is
such and
the
such.
one which was used, isn't it, 1994?
Yes, my lord, as amended from time to time, except in respect of things done or omitted to be done before such supersession, the Governor of Mizoram hereby make the following rules. The Mizoram School Education Department terms and condition of appointment of teaching and non-teaching staff of provincialized rules 2023. Now, my lord, coming to Rule 3. Mode of appointment of teaching and non-teaching staff of provincialized schools. All existing teaching and non-teaching staff on the effective date of provincialization not exceeding the limit prescribed by Rule 6 to A to E of the so-and-so rules shall be observed in government service in suitable ranks or grades with effect from the said date, subject to suitability for appointment in government service as per the eligibility prescribed by the recruitment rules in force at the time of their initial appointment, as may be determined by the competent DPC constituted for various categories of government employees by the government of Mizoram. The incumbents absorbed into government service shall be deemed to be employees of the government with effect from the date of provincialization of the school. 1. Roman 1. Principals. This is relevant, my lord. The existing principals shall be absorbed as lecturer in their respective provincialized schools or other provincialized schools or other vacant post of existing government higher secondary school according to their specialized subject, as the case may be. All posts of principal shall be filled up by promotion of the eligible lecturers of the government higher secondary schools in accordance with recruitment rules, service rules in force on the effective date. Here, my lord, we are concerned with principal. As of now, they have mentioned that the existing principal in the provincialized schools shall be observed as lecturer in the respective school. But at the time
This
of
is a recent one.
Yes, my lord.
2023,
Yes, my lord.
yes.
Now, I'll take a lordship to the relevant, if I may take a lordship to page number 104 of the writ appeal, 104.
Yes.
Running page 104. Petition is made on the right top corner, my lord. This is a notification dated 10th October 1990. And this is called the Mizoram Middle School and High School Provincialization Rules 1994. The relevant portion is in page number 106, my lord. 106, Rule 6, bottom of the page, Rule 6. Absorption of teaching and non-teaching staff of provincialized schools. All existing incumbents of the provincialized school in which they were serving on the effective date shall be absorbed in government service in suitable ranks or grades with effect from the said date, subject to suitability for appointment in government service in consonance with the corresponding and relevant recruitment rules framed by the department concerned and in force on the effective date as may be determined by the competent DPC constituted for various categories of government employees by the government of Mizoram and subject to the availability of sanctioned posts for such provincialized school. The next proviso is concerned, my lord. Provided that 50% of the post of headmaster shall be filled in by absorption of existing incumbents of the post of headmaster of the provincialized schools, and remaining 50% of the post of headmaster shall be filled in by promotion of the eligible teachers of the government high, middle schools, as the case may be in accordance with the recruitment rules in force on the effective date. My lord, well, considering the case of the private respondent, the respondent authority had applied this provision wherein there is a provision for absorption of the existing headmaster. But they have oversighted this page number 111, my lord, the following page, page number 111, wherein there is an amendment to this particular provision. Running page number 111. This is notified on 12th August 2002. These rules may be called the Mizoram Schools and High School Provincialization Amendment Rules 2002. And second para, my lord, amendment of Rule 6. We are concerned with Rule 6 of the principal rules. Now, amendment of Rule 6, my lord. In the middle school and high schools, provincialization rules 1994, in Rule 6, for the first, second, and third proviso, we are concerned with the first proviso. The following provisions shall be substituted for the first, second, and third proviso. There are three provisos in the principal rules. Namely, provided that the upper age limit prescribed in the relevant recruitment rules shall cause no bar to any of the teaching and non-teaching staff of the provincialized schools so observed. Next, my lord. Provided further that the existing headmaster who are not appointed headmaster under this rule shall be appointed teachers at their respective provincialized schools and shall be deemed to be the employees of the government with effect from the date of provincialization of the schools subject to their suitability in consonance with the relevant rules. Here, my lord,
So you're saying the private respondent,
he was
he was
the,
appointed as the headmaster
yes, my lord,
without looking into this proviso, which
Yes, my lord.
amends the previous, 1994?
94, Rule
rules.
6.
Okay. And what is your grievance? You are supposed to be appointed in place of the as a headmaster
Yes,
in
my
place
lord.
of the
Yes, my
respondent
lord.
number 6.
We have been rendering as lecturers, and we are the senior most. And due to his promotion, my lord, he was placed on top of us, and he will be debarring for further promotion to the writ appellants hearing, my lord.
But when the matter was heard before the learned single judge, wasn't this amendment brought to the notice?
My lord, this which I produced before your lordship is part of the affidavit in the writ proceeding, my lord.
But
This-
at the time of hearing the matter, simply making it a part of the affidavit, if it was not mentioned, was this brought to the notice of the learned single judge?
That I cannot say because I'm not handling in the before the writ proceeding, my lord. Now coming to the
So,
impugned
wait,
judgment, my
wait,
lord. Yes, my lord.
So I'm just wondering,
Yes, my lord.
if this point was not mentioned at all by the learned single judge in its judgment, okay, then maybe at the time of hearing, because the learned single judge in its judgment and order would obviously take down the submissions, mention the submissions made by the learned counsels, isn't it? And if this point was not noted by the learned single judge as one of the submissions made by the counsels in the court, then most probably it was not brought to his notice. Because maybe this amendment was not discussed, you're saying, in the judgment, then won't it be more appropriate if this matter, by way of a review of its judgment to see?
That we have also think about that a couple of times before filing this appeal, my lord. But not only on that point, my lord, we want to address the
Okay, there are other points
the
which are
impugned judgment
mentioned
also,
in
my
the
lord.
judgment.
Yes, my
Because
lord.
if it's just that, then you can brought to the notice of the learned single judge that this was not reflected. And maybe at the time when verbal submissions were made, it was not mentioned and not brought to the notice, isn't it? Okay, what are the other points?
Yes, my lord.
What's wrong with the judgment?
As it is, my lord, even assuming that the rules of 1994 itself is to be taken into account, that provincialization absorption of the staff, teaching and non-teaching staff has to be done by considering the suitability with the relevant recruitment rules. Now coming to the recruitment rules of the post of principal of higher secondary school, my lord, the eligibility criteria amongst others is that for the purpose of promotion, they have to render service as selection grade lecturers and or 5 years, minimum 5 year service as senior grade lecturers, my lord.
Where's that?
Yes, my lord. Page number 56, my lord. This is the Mizoram School Education Department Group A Post Recruitment Rules 2017. And if I may take a lordship to page number 58. Column 1, my lord. Name of post principal, Government Higher Secondary School. And on the next page, on the following page, page 59, column 11. Column 11, 50% by promotion, 50% by LDE. So only by way of promotion and this LDE can be filled up. And on column number 12, my lord, the criteria for promotion. From lecturer, government higher secondary school on regular basis in selection grade, having Bachelor of Education, failing which from lecturer, government higher secondary school in senior grade, having Bachelor of Education with 5 years of regular service in the grade. Likewise, as for the departmental examination, my lord, LDE. So the private respondents was never in the government service as neither as selection grade or 5 year service of senior grade.
What about you? Were you eligible then?
Yes, my lord, we are the senior most amongst the lecturers of government higher
Okay.
secondary schools.
So you are eligible as per the
Promotion.
column 12 for
Yes, my lord,
promotion.
promotion.
While the respondent was not eligible, that's
Yes,
your
my lord.
point.
Yes, my
Now,
lord.
what was the reasoning made by the learned single judge?
And
What's wrong with it? How, if these are the rules, then
this school was provincialized by notification dated 10/7/2018, page number 67. Page number 67. Notification dated 10th July 2018. In pursuance of the decision, item number 39 of the minutes of the meeting of the Council of Ministers held on 4th June 2018 and 12th June 2018 conveyed by number such and such, and in the interest of public service. The Governor of Mizoram is pleased to order taking over of C. Zakuma Higher Secondary School scholarship by the Government of Mizoram with immediate effect. By taking over C. Zakuma Higher Secondary School, the word government shall be prefixed before the name of the school. However, post-creation, absorption of existing staff, etc., involving financial implication will be done later subject to the approval of DP and ARW and Finance Department. And thereafter, my lord, on the following page, at page number 68, notification dated 27/9/2018. They have created post.
okay, for that particular school. Is it?
That
No.
school was provincialized, and thereafter they have created post.
For government,
Yes, my lord.
Caesar Kuma,
Yes,
yes.
my lord. Notification dated 27/9/2018. 27/9/2018. In pursuance of the decision on item number 39 of the minutes of the meeting of the Council of Ministers held on 4th June 2018 and 12th June 2018 conveyed by number such and such, and in the interest of public service, the Governor of Mizoram is pleased to order creation of 16 teaching and non-teaching posts for government higher secondary school as shown below. My lord, we can see that one post for principal and for lecturers 12 posts and non-teaching staff 3 posts, my lord. And it is well known that, my lord, once a private school is provincialized and posts are created under the government, that becomes a post of the government, and it should be filled up in terms of the relevant recruitment rules.
Okay, so in the instant case, since the private respondent was already working in the school, he's been made the principal.
Yes, my lord.
Is that your case?
Yes, my lord.
Okay.
Against the rules, my lord.
Ah.
After,
Then what is the reasoning of these learned
before that, my
single
lord, I'll
judge?
take a lordship to that.
Okay, okay.
After creation of this principal post, my lord, it becomes the post of government, the promotional post of government higher lecturers under the government higher secondary school. And page number 69, my lord, page number 69, MPSC recommendation. Consequent upon the provincialization of ad hoc Zakuma Higher Secondary School, the Department of School Education submitted a proposal to DPNR for absorption of one post of principal in the level of such and such. The department obtained concurrence of the Finance Department for absorption. According to the approved Mizoram Middle School and High School Provincialization Rules 1994 and its subsequent amendment, all existing incumbents of the provincialized school in which they were serving on the effective date shall be absorbed in the government service in suitable ranks or grades with effect from the said date, subject to their suitability for appointment appointment in government service in consonance with the corresponding and relevant recruitment rules framed by the department concerned and in force on the effective date as may be determined by the competent DPC constituted for various categories such and such. Here, my lord, they have recommended teaching and non-teaching staff, including the respondent number 6 for the post of principal. And on the following page, page number 70, this is the impugned notification. Notification dated 29/5/2019. We are aggrieved with the absorption of this serial number 1, Nang Hiloba Chinza, as principal. And in spite of the fact that this absorption has to be done in accordance with the provincialization rules as well as the relevant recruitment rules, my lord, although he is ineligible, he was illegally absorbed to this post.
Yes.
And now coming to the impugned judgment, my lord, impugned judgment and order, which is annexed just next to the index, my lord. I'll read from the beginning, my lord. For
On
better-
page?
On the, just next to the index of the appeal. On the front, just next to the index of the appeal.
Yes.
WPC number 89, 2019. Have you got it, my lord?
Yes.
There are two writ petitions clubbed together, and
Why the two writ petitions?
it is
clubbed
specified, it
together?
is defined in this order, my lord. Roman number 4, have you got it, my lord? Date of hearings 13/3/2023. Date of judgment 17/3. This matter was kept CIV and it was pronounced later. Heard Mr. Such and such learned counsel for the petitioners, Mr. and so for the state respondents, and Mr. So and so for the respondent number 6 in WPC number 131. The learned counsel for the MPSC, who was also appears for the respondent number 6, is not present today. He had earlier submitted the respondent MPSC that the MPSC will not be filing affidavit in WPC such and such. The MPSC in the respondent number 6 has, however, filed their affidavit in
Okay, so one is filed by the affected individuals and the other by the association,
Yes,
but
my
the
lord.
subject matter is the same.
Yes, my lord.
Okay.
And page
So,
number
no, in the,
para
in-
para
wait,
12,
wait,
my lord.
before that, in the instant appeal, it is only the private
Yes, my lord. If you
parties
lost
who have come
if
on
you lost
appeal,
mechanism para
not the other,
Yes, my lord.
this thing, okay.
you
Not the
lost kindly
association.
come to para 13, page Roman number 12, para 13 of the say judgment, my lord. Para 13. WPC number 89 is filed by Service Association Islam, and there is no dispute to the fact that the same is not a registered association.
Okay,
Here, coming to the conclusion, my lord, bottom of the para. Therefore, the writ petition filed by WPC number so and so
okay,
is
so
found to
one
be not
has been
maintainable and same is dismissed.
Okay.
Let us now proceed to examine the case of the petitioners in WPC number 131 as projected by them. As may be noticed, the rules of 2017 provides that the post of principal has to be filled up 50% by way of promotion amongst those who are eligible as per column 12 of the rules of 2017 and remaining by LDE. The Council of Ministers in the meeting approved the establishment of Government Higher Secondary School in Kolasi District, and in terms of the approval, since the Kuma Higher Secondary School was taken over by the government by notification 10/7/2018 with immediate effect. In other words, the school was provincialized as Government Higher Secondary School with effect from such and such. The notification further provided that post-creation absorption of existing staff involving financial application will be done later subject to approval of DPNR and Finance Department. By notification dated 27/9/2018, after obtaining approval of DPNR and Finance Department, 16 posts, both teaching and non-teaching staff posts, including one post of principal, was created for provincialization of the said school concerned. And thereafter, on recommendation of the MPSC, the service of the respondent number 6, along with 11 lecturers and 1 UDC were absorbed against the respective posts indicated by notification dated such and such. According to the respondent authorities concerned, absorption was done in terms of the provincialization rules of 1994. Rule 6 of the provincialization rules provides for absorption of teaching and non-teaching staff of provincialized school. The same is abstracted hereunder.
Yes,
I will
this
not
is the
read this part.
1994
Only
Rule
the-
6, which has been
Yes, my lord.
already amended,
Yes, my lord.
isn't it? Yes.
The learned single judge had referred only the
Right on
principal
this.
rules. In light of this, my lord, the impugned judgment was made.
So that's what I'm saying.
And besides it, my lord,
Uh,
I will read it later.
Yes, yes.
The findings, one of the findings which is being impugned is that the learned single judge held that those posts, more particularly the post of principal, which was created after the school was provincialized, is deemed as specifically mentioned for the existing staff from the said school. That is illegal, my lord.
But there's still a but, okay? But if the learned single judge was aware of the fact that this Rule 6 had been amended, then would it come to the same finding that it came to in the judgment?
No,
That's
my
one
lord.
question.
That
It won't have-
that
it
will not be
won't come.
possible because
Yes.
the entire thing, the
So because
provincialization
of
was.
that, let's look at the initial part of the judgment as to what were the submissions made by the parties, isn't it? Because these are the points, based on the submissions, this was considered. So maybe if the amendment of Rule 6 was not mentioned, then wouldn't it be more appropriate if it came by way of a review?
My lord, this writ appeal being filed last year and been pending for more than a year. And this honorable court, as a decision bench, can
But now
pass
today,
necessary order.
but today we are going to discuss an issue which was not mentioned at all or referred to by the learned single judge. See, we are now going to discuss something
Now, my lord,
which
during
appears
pendency,
was not placed before the learned single judge about the amendment of Rule 6.
now, my lord, during pendency of the appeal, my lord, the petitioners, appellants have also approached the respondent authorities on several occasions. And the respondent officials also have accepted that they have did this illegally without referring to the amendment, my lord. And keeping in view that the private respondent choose not to contest in the writ appeal as well as while considering the delay, my lord.
But you see, that's a different matter. But you have approached this court to set aside the judgment of a learned single judge. Okay. That's the only thing. And it appears that all the facts were not presented before the learned single judge. What do you think? Yeah, because when we, whatever the latest stand of the respondent is, that's a different matter. But this is for setting aside of the judgment of a learned single judge, where it appears that the amendment of the mentioned Rule 6 was not placed before him. And you're saying, had that matter been placed before him, the learned single judge would not have come to the finding which is there in the judgment.
My lord,
Isn't it?
to be fair, we both were representing the parties before the learned single judge. And my lord, this amendment rules was annexed in my affidavit in opposition.
but
But then
did
it
you
was
point
never brought or highlighted or bring to the knowledge of the learned single judge
then-
by the petitioner and by us also.
By, yes,
Yes,
then,
by the parties. But my lord, why the matter is
If the rules were appended, then was it mentioned in the affidavit that about the amended rules?
As amended from time to time.
Yes,
As
amended from
as
time to
amended
time.
from time to time.
simply as amended from time to time, but it was not specifically shown.
My lord, why the matter is mentioned to be listed today by my learned friend yesterday is that as per the instructions that I have received, the state respondents do not have any objection in the writ appeal.
You do not have any objection? They are not-
In the writ appeal.
But then, okay, then we'll have to mention.
It was not in the writ petition. Earlier it was not in the writ petition.
It was annexed, but at the time of hearing, they did not press on that, which the pressing did. So I think the learned single judge had given the dictation as per the submissions made, the dictations were made in the court. And they should have done the same and mentioned the amendment. Because in the judgment, it appears in the judgment of the learned single judge, nothing of the amendment has been mentioned. So that point was not considered at all.
Because it was not brought to the knowledge
The
of the learned
knowledge, I
trial judge.
know. So,
Single judge.
so then we're asking that set it aside when that point itself was not, that's why I'm saying, isn't it more appropriate if a review petition is filed? Even if you are not challenging it now, So when you were aware, the state respondents, when you were well aware of the amendment, you didn't really have to file a counter affidavit. You should have conceded then instead of conceding here at the time
At
of
that point
appeal.
of time, at that point of time,
Now they have
even though it was in
Now you're accepting it.
Yes.
So at that time, when the matter was placed before the learned single judge and you were well aware of the amendment of Rule 6, then you should have conceded at that time itself and said, okay, we will not challenge the writ appeal because these are the facts. Isn't it?
the case of the
Now in appeal, you come and say, okay, we don't want to challenge. When you were well aware of the amendment then. That's what. No, so I think maybe.
In my humble opinion, my lord, after pointing out that whether the absorption of the respondent number 6 has been done suitability for appointment in government service in consonance with the relevant rules and the relevant RR, my lord.
Maybe
This
only
what-
on that point, not on the amendment.
But all the relevant rules which are in record has to be considered, my lord. Otherwise, how can this illegality be allowed to be perpetrated
That's
further, my lord?
That's why we are saying when a certain point was not brought before the learned single judge. And on that point, the appeal, you mentioned that in the appeal. And your point is that the amendment clearly shows that the appointment of the respondent, private respondent is actually wrong and he's not now contesting the appeal. That means in the writ petition itself also, the writ petition should not have been contested. Well, the amendment was there inexistent at the time when the writ petition was being mentioned. Now the state government is saying, oh, because of the amendments was already there, we are not going to contest, when it should have been disposed of then, isn't it?
Yes, but during the at the
So
time
new
of
facts have been brought to light.
Yes.
Then I think it's more appropriate that you file a review petition. Let the learned single judge, all the facts of the case be brought before the learned single judge. And then you can mention that now we are not going to appeal, then it can always reverse its order. Because if we don't, and now we are saying that maybe if we just look at the judgment and see what are the points, then we cannot include the amendment. Well, the amendment has to be included because you have brought that to the notice of the court. Are you getting my point?
I'm getting your point, but your lordship, in my humble opinion, my lord. Now, after brought to the knowledge of this noble court that there's an amendment, specific way, the manner in which absorption is to be done. And when that was not complied with, and after taking cognizance by this honorable division bench, my lord, this court has the power as well to mend the illegality.
My lord, if I may intervene, my lord, in the last court date, if your lordship would kindly see the order, it will be mentioned that amicablement is attempted by the parties. So, yes, on this, yes. So in that light,
So attempts have been made. Is there any progress? Last court date you mentioned that, but
Yes,
is
my
there
lord.
any
Yes, my lord.
progress?
Now, as submitted by my learned friends, he has received an instruction that they have no objection against the appeal.
Instead of having no objection against the, okay.
so attempt in that light,
Okay, we'll dispose it of.
to enable
And
the
more on that light.
Yes.
Okay, instead of you see, our problem is we have to set aside a judgment of the learned single judge. Okay, when the learned single judge was not made aware at the time of hearing concerning the amendment of Rule 6. So the learned single judge, based on the provision of the Rule 6, along with the other facts that were brought before him, he had passed a judgment. And you're saying, had the learned single judge been aware of that amendment, it would have made its decision as it made in the writ petition they appealed against. Isn't it? Anyways, so I think we will pass an order based on the fact that in the appeal, at the time of hearing of the appeal, the respondents, the state respondents, submit that they will not file any objection to the appeal and allow the prayer of the appellant. It's not been challenged. I think on those grounds, considering those facts and the fact, then we will mention what the document which was produced before us. This was not there at the time of the judgment and order,
It's not the recent one.
the recent one, and in view of this, okay, this is the position, and therefore, I think we can pass an order and dispose
Yes,
it
my
of
lord.
accordingly.
And the
Yes. And,
impure notification absorbing the private respondent.
will be set aside.
In that,
based-
my lord, I just clarified, there are also other officials,
Don't
staff.
press on those
Only,
matters,
only, it has to be modified to the extent of absorption of the respondent number 6, page number 7070.
Yes. Or let's look at the appeal, your prayer portion in the appeal. Let's look at that. Okay, what did you pray for?
Page number 23.
23. Because we cannot divert too much also.
Yes, my lord. I have made a specific prayer.
Yes, page number 23, where? Judgment and order passed by should be set aside and quashed, and the notification, 29, this is the imputed notification,
Please go.
29/5/2019. So far as the illegal absorption of respondent number 6 upon so,
Yes, ma'am.
okay, this should be set aside, only this point, isn't it?
Yes, my lord. This notification is in page number 70.
Yes. So since this appeal, prayer has not been contested or challenged, opposed by the
Yes, my lord.
state respondents, we'll allow it. I think we'll leave it at that.
Yes, my lord.
Okay, instead of discussing it too. I'll pass a full order later.
Yes, madam.
So appeal allowed in this court. Yes.
Deeply obliged.
Item 13.
I'll pass the order later.